Welcome to This Explainer. Today we're diving into something that honestly sounds like the plot of a massive Hollywood blockbuster, but it is actually the fascinating high-stakes reality of international shipping law. We are looking at the incredibly well-designed legal safety nets created to protect abandoned and lost mariners. So let's dive right into this. I want you to think of these laws not as some dry text in a dusty legal book, but as an active, cinematic rescue operation just waiting for the signal to launch. To truly get a grip on this, I want you to picture a brightly lit, bustling dock right at dawn. A colossal cargo ship is gearing up to leave. And in the midst of all that chaotic action, a seafarer might be accidentally or even intentionally left behind. Or, taking it to an even more dramatic extreme, a vessel might just be completely lost in the vast open ocean. When a mariner faces their absolute darkest hour, the law doesn't just leave them adrift. We're going to explore exactly how the legal framework steps in, kind of like a perfectly timed movie hero to save the day and bring them safely home.
Act 1. The Incident. Missing or Lost at Sea.
Okay, so under Section 90 of the Shipping Act, the stakes are laid out super clearly for a seafarer who is missing or lost at sea. It is a terrifying thought, for sure, but the law has a plan. When the worst actually happens, this legal rescue protocol acts incredibly swiftly in three very distinct steps. First up, the central government, or an officer they specifically appoint, immediately steps onto the scene to take full charge. Second, they forcefully recover all the wages and compensation due to that missing mariner directly from the ship's master, the owner, or their agent. And they can do this in the exact same court and manner as standard wage recovery, which basically leaves zero room for evasion. Finally, they distribute those funds with the exact same care and legal framework used for the wages of deceased seafarers. The priority here is clear, absolute, and decisive. The family and the estate are fiercely protected, and the shipping company is held completely accountable.
Act 2. The Cavalry. Stranded abroad. But what if the seafarer isn't lost at sea? What if they're very much alive, but stranded alone in a bustling foreign port thousands of miles from home with absolutely no money? Well, enter the cavalry. Under Section 91, the Indian ambassador, or an equivalent diplomatic rep stationed near that port, literally becomes the hero of our story here. If the abandoned seafarer applies for help, the ambassador doesn't just offer, good advice or a sympathetic ear. They are legally obligated to step in and provide a tangible, immediate lifeline. They have to arrange for the seafarer's safe return to a proper home port, and crucially, they must provide necessary clothing and maintenance while that mariner waits for their journey home. In the legal world, these life-saving provisions are defined as repatriation expenses, and it is a comprehensive package. It ensures the mariner is clothed, fed, maintained, and given a ticket home. This even covers the costs of conveying and maintaining a shipwrecked seafarer who has been miraculously rescued and brought to a foreign port, so it's a complete blanket of protection. However, we do have to remember that an abandoned seafarer doesn't just get a blank check. These rights are subject to specific prescribed conditions to make sure the system stays robust and doesn't get abused. Act 3. The Reckoning. Who exactly pays the bill?
Because, let's be real, every dramatic rescue operation comes with a hefty price tag. Flights, hotels, food, it all adds up fast. And the legislation actually has some very strict, highly fascinating rules about exactly who settles this final debt with the central government. But before we can figure out who foots the bill, we have to look at a major plot twist in the law: accepted expenses. This completely flips the legal script. I mean, what if the seafarer wasn't a victim of circumstance? What if they were left behind because they deserted the ship, went AWOL, got thrown in a foreign prison for misconduct, or were rightfully discharged for bad behavior? In those specific cases, the money spent rescuing them falls squarely under accepted expenses. Now, this distinction creates what you could call the ultimate duel of debts. On one side, we have standard repatriation expenses. If a seafarer is abandoned through absolutely no fault of their own, that debt belongs entirely to the ship owner, the agent, or the vessel itself. The government bills the owner, and the owner is legally forbidden from trying to squeeze that money back out of the innocent seafarer. The shield is totally impenetrable. But on the flip side, if it's an accepted expense, meaning the seafarer caused the mess through their own misconduct, the seafarer and the ship owner become jointly and severally liable to the government. So the government can still get its money from the owner, but the owner can then legally turn right around and recover those costs directly from the seafarer's hard-earned wages.
So the really crucial point here is that Section 91 gives ship owners a very sharp tool, but heavily restricts how they can actually use it.
If the owner steps up and directly pays these misconduct-related accepted expenses out of their own pocket, that immediately becomes a debt the seafarer owes the owner. The owner has full explicit rights to satisfy that claim by taking it straight out of any wages owed to the seafarer. But again, the law is exceptionally bright and clear on this. They absolutely cannot touch a single penny of the seafarer's wages for standard, faultless repatriation expenses. The safety net remains fiercely protective of the innocent, ensuring they are never, ever punished for a crisis they didn't create.
Now, you might be wondering who on earth coordinates all of this behind the scenes. Well, it's crucial to note that this entire logistical chain is anchored by an official known as a shipping master. This is the official located either at the port where the seafarer originally signed their employment agreement, or if no agreement was made in India, the port where they were expected to return after their voyage. They essentially act as the bureaucratic anchor point, navigating all the complex paperwork and keeping this whole massive operation grounded and perfectly organized.
And then, the finale. When the bill finally comes due and it's time for the central government to actually collect the debt they are owed, they don't have to fight some massive, drawn-out legal battle. According to the Act, simply producing the account of the expenses and the proof of payment serves as prima facie evidence. Basically, the receipt itself proves the debt is valid. Boom! It's an instant victory condition. This allows an authorized officer to efficiently and cleanly recover the debt in the exact same streamlined manner they use to recover unpaid wages under Section 86 of the Act. The rescue is complete, and the books are perfectly balanced.
So as we wrap up this explainer, I want to leave you with this final thought. We've seen how the law acts as this powerful, brilliantly designed safety net, swooping in to clothe, feed, and rescue stranded mariners with literal cinematic precision. But we've also seen how quickly that net shifts into a mechanism of strict accountability if the mariner is at fault. So if the entire system hinges on determining who is to blame in a foreign port, you have to ask yourself, who truly holds the power when a seafarer is abandoned thousands of miles from home? It is a truly fascinating balance of maritime justice and real-world impact that keeps the massive gears of global shipping turning smoothly and fairly. Thanks for learning with me today.